Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. In this edition, we look at major changes to probate law. And the biggest change is that the federal estate tax was increased for estates to be able to give, without federal estate tax, $5 million. So, after a 1 year hiatus, the estate tax was reinstated for 2011-2012 with a top rate of 35%. The exemption is $5 million per individual for 2011 and will be indexed to inflation in 2012. Estates of people who died in 2010 can choose either follow the rules in effect for 2010 or 2011. The Act sets a $5 million generation skipping transfer tax exemption and 0% rate for the year 2010. Let's say, for example, in New Jersey, let's say some people says, well, that's great. Then there's not going to be any tax at all. However, New Jersey has an estate tax on amounts over $675,000. So even if there is no federal estate tax due, let's say in New Jersey, if the estate's over $675,000, you still have to file a federal estate tax return, plus a New Jersey estate tax return, and pay taxes. And that's important because New Jersey imposes a high tax. Let's see. Next major addition was that non-formal writings could be wills under the revised probate law. Senate Law 708 made a number of substantial changes to the provisions governing the administration of estates and trusts in New Jersey. The adoption of portions of the Uniform Probate Code attempted to bring greater uniformity to the rules governing testamentary and non-testamentary transfers to make most state laws similar. Let's see. However, what the law has expanded situations where writings were intended as a will would be allowed, but requires the burden of proof on the proponent to be by clear and convincing evidence. Conceivably, if there was a Christmas card that had handwritten notes that said that someone wanted to make a bequest, or someone could go to court, file a complaint, order show cause, present this handwritten Christmas card as a codicil to a will. Let's say to present a non-formal will, let's say a writing, this requires an expensive complaint and order show cause to be filed in the Superior Court in a hearing in front of a judge. So we always recommend be careful, have a will done properly by an experienced attorney. There's also a recommendation for self-proving wills. Let's say an old New Jersey probate law simply required that that there be two witnesses. But then one of the two witnesses to the will had to travel and appear in the surrogate's office and sign papers that said they were witness. This often created problems where one of the witnesses would die, move away, or simply couldn't be located. Some witnesses would require a $500 fee just to simply sign a surrogate paper. The New Jersey legislature later passed a law to create a type of will called a self-proving will. In such a will, the person for whom the will is made must sign, the two witnesses sign, and then the attorney or attorney's notary sign, with statutory language to indicate the will is self-proving. When it's done properly, the executor does not need to locate the witnesses. Let's say, if your will is not self-proving or you're unsure, schedule an appointment with an experienced attorney to make sure the will is done correctly. Now, there's also a revised statute in New Jersey that now requires palimony agreements to be in writing. And this was to overrule the case of Estate versus Vercammen. The New Jersey Supreme Court also held that in the case of the estate of Stockdale, that where there's a confidential relationship coupled with suspicious circumstances, undue influence is presumed, and the burden of proof shifts to the will proponent to overcome the presumption. And that's the case of estate of Stockdale. Now, gifts are permitted without gift tax. That was increased the prior year to $13,000 per person, but the amount permitted for Medicaid transfers is zero.